Hi, this is Attorney Kip from Malik & Malik. Today I'm going to be talking about what I'll call the Frankenstein line of cases, and you'll see why I call it the Frankenstein line of cases. And essentially, these cases deal with amputation and scheduled loss awards. And why do I call them Frankenstein cases? Because they're situations where somebody's had a body part amputated and then they have it reattached into the same place where it was lost or a different part of the body. So I call them the Frankenstein series of cases. And there's three cases. The first one's Welker, the second one's Qiblawe, and then the third one's called Mast. And they kind of, one happens first, and then they kind of build off that one, and then the third one, Mast, builds off the other two. So Welker, what ended up happening is this individual had their thumb in an industrial injury nearly amputated. It was hanging up by a thread of skin, apparently, and they went to urgent care, and then they eventually went to a surgical center, and the thumb, it was reattached, and so they filed a scheduled loss award for the lost use of the thumb. Remember, it was hanging by a little piece of skin, then it was reattached. And what the court ended up saying is, you look at scheduled loss awards in terms of digits and body parts from the standpoint of the surgery, after the surgery on that body part. So you don't look at at the time of the amputation. You look at the time of reattachment, and whether or not after reattachment, if the amputated and reattached digit is functional. So in this case, the court said, yeah, the thumb is functional, so that individual didn't get a scheduled loss award. The next case is Qiblawe, and in Qiblawe, what ended up happening is the individual lost their index finger was amputated, an industrial injury, and then so they had this space in their hand, in their left hand, where they had all the other digits except the index finger. And so for functional purposes and aesthetic purposes, it was decided to move the pointer finger to where the index finger sits. So and before this point, the individual had filed for a scheduled loss of the index finger because the index finger was amputated and it was gone as a result of the industrial injury. So the surgeon, amputated the pointer finger, moved it over, and reattached it to the index finger, the point on the index finger. And then that person, so they had previously filed for lost use of the index finger, but they also filed for lost use of the pointer finger as well. And the court said, no, after reattachment of, the pointer finger was amputated, but it was reattached and it was functional after that procedure, and therefore you cannot get a scheduled loss award for that digit. So that's Qiblawe. The third case would be this Mast case. So what ended up happening in the Mast case is, I guess all these injuries involve the left hand, apparently. So protect your left hand, folks. But so in this industrial injury, they lost their left thumb, their left pointer finger, and the left index finger. And then so what they ended up doing is they filed for a scheduled loss award of the entire hand based on a 2+ theory. So the 2+ theory is, if you lose two fingers in the hand, then the idea is for all intents and purposes, your hand's going to be severely impacted such that it's nearly that you've lost the use of the entire hand. Even though you've not lost the entire use of the entire hand, for all practical purposes you have. So they were granted the scheduled loss award for the entire hand, although they didn't lose the other two fingers. So in order to restore some pinch and grip strength functionality in that left hand, the surgeon decided to do a procedure called a toe to thumb transfer. And so the idea is they amputate a toe, and in Mast's case it was the big toe. They amputate the big toe and they move it to the place where the thumb used to sit. And it's not great, it's not a replacement for the thumb, but it does improve functionality in that now you have some grip strength, or some grip, and you have some pinch, and that's a lot of what the importance of your hand is, the pinch and the grip, and that's provided by the thumb. So this person had their big toe on their left leg, or left foot rather, amputated and placed on the place of the thumb on the left hand. So they ended up, because they no longer have a left toe, they filed for a scheduled loss award of the left toe. And the court said in that case, they are entitled for a scheduled loss of the big toe, and for 3 reasons. And the first reason is it's an amputation. It involves two different extremities. So for the left foot and the left hand, 2 different extremities. It's not like they're moving like in Qiblawe 1 digit over to the next digit. And then the other issue is they had not, and let me look at my other points real quick, but they had not previously gotten a scheduled loss award for their thumb. So they had gotten a scheduled loss for the hand, but they didn't get a scheduled loss of the thumb. And they said, and they said if they would have gotten a scheduled loss of the thumb, then maybe they wouldn't have gotten the scheduled loss of the big toe. Okay. And then the other thing is the court, using the prior precedent and the other case laws, again, we look at when it involves a reattachment, an amputation reattachment, we look at after the reattachment. So the big toe was amputated, it was reattached to, again, the thumb area of the left hand. But if we go back to after the amputation of the big toe, that individual no longer had a left big toe. So it was gone, okay? And it was gone because it's now sitting in the place of the thumb on the left hand. So for those 3 reasons, that individual was entitled to a scheduled loss of the big toe, whilst, even though they did get the loss use of the hand. So the question I have for you folks to consider is, let me propose a hypothetical. So what if an injured worker lost his thumb in an industrial accident and he did file for a scheduled loss for that thumb, and the surgeon, similar to the situation Mast, the surgeon did perform a toe to thumb procedure? Should he be entitled to a scheduled loss of the toe? So if we look at the prior 3 cases, under a strict fundamentalist interpretation of Welker, Qiblawe, and Mast, he would not be entitled to a scheduled loss of, either the big toe or one of the other toes. So under Mast, if we go, remember those 3 different things that we went through. So the amputation involved 2 extremities. So he's moving the toe, like in Mast, he's moving the toe from his left foot to the thumb. And then after the reattachment and recovery, he no longer had a toe. But the difference in this hypothetical versus Mast is this individual filed for a scheduled loss award for the thumb, and they were granted it prior to their request for the scheduled loss in this situation. So my question to you is this fair, or is this arbitrary and illogical? Because they're basically saying, well, you've got the scheduled loss of the thumb, so you don't get the scheduled loss of the toe. But does that make sense? You don't have the toe anymore. It's gone, right? You no longer have the toe. It's been transplanted. And I would argue it doesn't make sense. And I would argue a simpler solution would be, and this would, a simpler rule in these situations, in these amputation reattachment situations, is the digit that was amputated and reattached, is it reattached to the place where it's supposed to be? I.e., if you amputate your thumb and you reattachment, you shouldn't get a scheduled loss for a thumb in that instance. But if my position would be, if you amputate your pointer finger and move it in place of the index finger, I think you should get a scheduled loss of the index finger and the pointer finger, because you no longer have a pointer finger. It's gone, right? And it's in a weird place, and also it's compromised. You've cut it, it's been moved. It's never going to be the same as where it was previously as a pointer finger. So that's my simple rule. That's not the case law in Ohio currently. Possibly if one of these situations ends up going to the Supreme Court, if we have a more liberal Supreme Court, potentially the law could change. As it stands right now, the law will not change, and it very well may be that if somebody does appeal one of these things to the Ohio Supreme Court, it will become even more draconian as far as the injured worker is concerned. So that is again, the Frankenstein line of cases involving amputation and attachment, reattachment. And as I say at the end of all these videos, workers' comp is a tricky beast, and you 100% need to get a workers' comp attorney involved. Don't do this stuff on your own. Consult with a workers' comp attorney. If you need a referral, ask your friends, coworkers, relatives, etc. Hey, who do you guys suggest for a workers' comp attorney? Otherwise, go on Google, search for a workers' comp attorney, talk to one attorney, talk to 5, find the one that vibes with you and sign up. It's going to pay you dividends. It's going to be well worth getting a workers' comp attorney involved. So this has been Kip from Alec & Malek. If you have any questions, comments, you could either leave them in the comment section, you could email me, you could call my office, and I hope you stay safe, and thanks for watching this.